Hello and welcome. In this lecture, we'll be exploring the Multi-State Professional Responsibility Examination, which also called the MPRE. The MPRE is a requirement for the bar exam, and it is administered by the National Conference of Bar Examiners. It provides a focused review of the ABA Model Rules of Professional Conduct, which regulate lawyers, and the ABA Model Code of Judicial Conduct, which regulate judges. It gives an understanding of the key ethical duties, such as client confidentiality, conflict of interest, competence, advocacy, professional responsibility. It develops examinees' analytical skills and test-taking strategies for the MPRE. It helps participants confidently pass the MPRE and uphold the high standards of the legal practice. The regulation of the legal profession set standards and guidelines that ensure that lawyers and legal practitioners meet the necessary requirements in order to practice law. Lawyers are regulated by the ABA Model Rules of Professional Conduct, the ABA Rules of Judicial Conduct, state Supreme Courts, state bars, together with disciplinary boards, legislature, federal courts, and administrative agencies. The court's power to legislate or regulate lawyers is done by the admission to the bar, also by creating and enforcing ethical standards, disciplining lawyers in terms of misconduct or contempt of court. Secondly, state bar association and disciplinary agencies also regulate lawyers by investigating complaints about lawyer misconduct, prosecuting ethics violation, recommending or imposing sanctions, overseeing continuing legal education of lawyers, and the administration of the bar exam, character and fitness evaluation. Now, there is also the component of legislative and administrative oversight, which regulates the unauthorized practice of law. Furthermore, it also regulates the lawyer advertising fee structures and abolishes government lawyer conduct rules. We'll delve into that in a little bit. Federal versus state regulation. Lawyers are primarily regulated by the state where they are licensed. However, federal courts do regulate lawyers as well, especially when there is a violation of the legal rules, regardless of the jurisdiction that the lawyer is licensed in, and we'll delve into that in a little bit. The state bar admission requirement. First of all, a lawyer must have a legal education such as a JD from an ABA accredited law school. They must pass the bar exam. They need to as well pass the MPRE, pass their character and fitness evaluation. And under Rule 8.1, the lawyer must not make false statement or fail to disclose information that is being required for their admission, or knowingly fail to respond to a lawful demand of information from disciplinary authority. Now, all this is a requirement for bar admission. Failure to disclose that information may result in a student being barred from admission to the bar exam. There's also a moral, character, and fitness requirement of practice law. That means that factors that may raise concern include criminal history, substance abuse, financial irresponsibility, academic dishonesty or misconduct, false statements or omissions. So there may be an obligation to disclose, for example, past arrests, civil lawsuits, academic discipline, and employment history. After a lawyer is admitted, the regulation continues where they may be subjected to discipline for violation of the model rules of professional conduct, also criminal act, dishonesty, or failing to report as a lawyer's violation under Rule 8.3, any conduct that is prejudicial to the administration of justice, improper influence on official, in this case, bribery, or misconduct outside of law practice. Now, such acts have to be reported. If a lawyer engages in an act that is a violation, they need to be reported by another lawyer that is aware of the act. And this leads us to what's called a mandatory and permissive reporting of misconduct. Now, it is mandatory under Rule 8.3a or the model rules if a lawyer, one, knows of the misconduct. Number two, the misconduct raises a substantial questions to that person's as to the other person's honesty, trustworthiness, or fitness as a lawyer or a judge. In such situations, the lawyer needs to disclose the information. There are exceptions. Number one is confidential information under Rule 1.6. In this case, the information which is protected under the duty of confidentiality must not be reported. Also, information that is a result of lawyer assistance programs under Rule 8.3c. For example, if a lawyer is involved with a client that is going through a rehab for substance abuse, so that information must not be disclosed because it's protected under the rules of confidentiality. Permissive reporting simply means that the lawyer, number one, does not know of the misconduct. And this misconduct does not raise a substantial question as to the other lawyer's integrity in terms of the honesty or trustworthiness and so forth. In such cases, that information is not meant to be disclosed. Unauthorized practice of law by lawyers and non-lawyers under Rule 5.5. A lawyer shall not practice law in a jurisdiction in violation of a regulation of the legal profession in that jurisdiction or assist others, including non-lawyers, in doing so. A lawyer not admitted to practice law in a state shall not establish an office or continuous presence there for legal practice, hold themselves as admitted to practice there. That is a violation. However, there are exceptions. If a lawyer is going to practice with another lawyer that is a local lawyer licensed in that jurisdiction, or the work is authorized by the court, or the lawyer is working in areas such as arbitration, mediation, or similar proceedings. Furthermore, situations also where a lawyer's home jurisdiction practice is the core of the work and does not require pro hac vici admission. Another situation is in-house counsel or government lawyers that are working without being admitted, but only if they're doing a work that is related to their jurisdiction back home. Now, unauthorized practice of law for non-lawyers is not permitted, and that means non-lawyers cannot give legal advice, draft legal documentation, represent clients in court, assist non-lawyers. Now, a pro hac vici admission means that a lawyer that is licensed in another jurisdiction may temporarily practice in another if they have the consent of court, if they've been allowed by the court. Now, the requirements for a pro hac vici admission is that the lawyer must be licensed and in good standing in their home state. They must file a motion with the court seeking pro hac vici admission, must associate with a local attorney admitted in that jurisdiction, pay a pro hac vici admission fee, and may need to comply with the requirements of the state jurisdiction. Now, fee division with a non-lawyer is not permitted. That is the general principle. Now, the reason is to protect the independence of the legal judgment and prevent interference by non-lawyers. So it is prohibited for a lawyer to share or split fee with a non-lawyer in situations such as giving a percentage of the lawyer's legal fees to a non-lawyer, paying bonuses tied to the amount of legal fees earned on a specific case, partnering with a non-lawyer in a business that provides legal services. So those situations are prohibited by law. However, there are situations where fee may be shared with a non-lawyer in situations of estate of a deceased lawyer. Let's say a lawyer has passed on and his estate is being spread out to his heirs. Also situations where paying a non-lawyer employee, paralegals, administrative staff, or a sale of a law practice, or payments to non-profit organization that recommend legal services. Now, lawyers have responsibilities if they are going to be managers in a law firm. They need to ensure that the firm has system in place to ensure compliance with the ethics rules. They need to supervise subordinates and ensure ethical conduct because they're going to be vicariously liable. That means that they are liable if they do ratify or to ratify the misconduct of their subordinates. They failed to mitigate or prevent it when they knew about it. Their responsibilities under Rule 5.2 is that also the subordinate lawyer must follow the rules by their supervisory lawyers. Now, there's a defense because the reasonable resolution defense states that if subordinate acts in accordance with a reasonable resolution by a supervisor, the subordinate is not responsible. So that means that if a non-lawyer or a subordinate lawyer is acting with instruction of a manager lawyer, then the firm will be responsible for the act. Now, non-lawyers and assistants have to make reasonable efforts to comply with ethical rules. And lawyers can be held responsible for staff misconduct if they direct or approve it. They knew about it and did nothing about it. Now, restriction on the practice of law. Lawyers should not be restricted to practice law. That is, for example, if a lawyer leaves a law firm, they should not have to sign papers or contracts with a law firm that they worked prior to moving to another law firm that they're not going to practice in certain areas of law. Now, this is to protect client choice and ensure that lawyers remain free to practice law and serve clients after leaving a firm. Now, there are situations that lawyers may agree to not practice in certain areas of law. For example, in situation of retirement agreements. Now, a lawyer may want to retire, therefore, they may decide not to practice law in certain areas anymore, and that is perfectly allowed. Now, settlements of legal disputes. A lawyer cannot agree not to represent others as part of settlement of a client claim, and that is not permitted by law. So this comes to the end of our lecture on the regulation of the legal profession.